So what we have defined so far is law. Law is a rule or a custom with an attached legal sanction. If you break it, you will be punished. Second is court. Court is a particular place where your rights and responsibilities are defined in case of a dispute, a legal dispute between you and another member of the society. Now next, what is the primary function of a court? The primary function of the court obviously is adjudication. Adjudication is resolve the conflict and disputes basing on the law. Second thing is interpretation of law. Law is a sentence or a rule that is written down. Now there may be a time that this particular rule is written down in 1850 and we are interpreting in 1950. 100 years have passed and there should be some authority who should interpret it correctly. Because depending on the time and place, words will change meanings, sentences will lose meanings, context will lose meanings. So interpretation of law is the second duty of the court. They give the authoritative interpretation. Third is application of law. This is the body which is given the authority to apply the law. Then you have administration of justice. Justice is what is being fair and impartial hearing. Justice means whenever you go to a court, what do you expect? You expect that your viewpoint should be heard. It may be correct, it may be wrong, whatever, but you should be heard. That particular rule is called audi alteram partem. Audi alteram partem means audi means listen. Listening to the alternative party, other party also. When you listen to both the parties and then you decide, that is called administration of justice. Now, courts have a hierarchical structure. There will be lowest court and the highest court. In a country, the highest court is always the Supreme Court. In India, we have Supreme Court of India. In USA, you have a federal Supreme Court. Then in each state in India, we have a High Court. That's sitting at the top of the hierarchy. Below that, you have district courts, and below that, you have municipal courts, and below that, small cause courts. And even below that, you have executive magistrate. These are the 4-5 levels of the courts that are available in India. Now, what is the difference between executive magistrate and the judicial magistrate? Executive magistrate has more preventive role and judicial magistrate has a adjudicative role. Next, define judge. The next point that you have to define is a judge. Now, if you have a court which is there to adjudicate a particular dispute, court cannot be existing in thin air. There should be a person who heads that court. That man is called a judge. So all the activities and functions of the court are done in person by the judge. So a judge is by definition, what do you want to do? What do you want him to be? What you want him to do is be impartial. Listen to both parties. Don't be biased either of them. Then you should have the authority given by the government of the day, because you have to impose sanctions. Impose sanctions, you are the material. You are the person who is the medium through which this sanction is imposed, through the government and the law. So his first duty is being impartial, second duty is being authoritative, then he should exercise the judicial power and he should administer justice. These are the 4 things that he does. So what does he do? First is preside over a case, second interpret and apply the law, make rulings or decisions, be impartial and neutral, adjudicate the dispute, ensure the due process of law is followed, and he should have the proper qualification. He should be selected by a selection process and he should have a defined tenure. You should not have a fear of tenure. If you have a fear of tenure, you cannot do justice. So these are things that are required. Next, there are some basic terms in law which you should understand, because it is a jargon. Whenever you have a specific subject, a new subject, there is a terminology, there is a jargon that comes out of it. Now, first thing is the person who approaches the court. The person who approaches the court with a dispute. That person who approaches the court is called a plaintiff, and the application he makes to the court is called a plaint. Okay? Next, the person approaches a court against a third person, against another member of the society. that person against whom you approach the court is called the defendant. That means you are going against the defendant for a particular adjudication. Now, you can have disputes of two kinds. One is civil kind, another is criminal kind. What is the difference between civil kind and criminal kind? In civil kind, it is a private dispute. The dispute is between you and the other person, completely private, where government or the state has nothing to do with it. Whereas in a criminal case, in a criminal dispute, it is you or the accused against the government. The victim has no role to play in it. So that is the particular difference, basic difference. Right? So in civil law, what are the kind of problems you have? Contract problems, property rights, torts, family matters, these are all in civil law. Then what is given in a civil law is damages. Now in criminal law, what is that you are pitted against the society as a whole. Because you commit a crime that is declared as a crime by a penal code. So now we have Indian Penal Code, and the process we follow is Criminal Procedure Code. Based on that, different items are classified as crimes. They are murder at the highest, then theft, assault, fraud, etc. as you go down. Right? So, civil law is governed by Civil Procedure Code, CPC, and orders and rules under it. Criminal law is governed by Criminal Procedure Code, CRPC, and then IPC is the substantive law. In case of civil law, the substantive law will be Indian Contract Act, Transfer of Property Act, or a tort law, or Hindu Marriage Act, or Muslim Marriage Act, things like that. So, next word is contract. Now, what is a contract? Contract is a binding agreement. If you break it, you will have to pay compensation. Simple as that. A contract is, there are two persons, they agree on a particular thing, and if any one of them breaks that particular agreement, other party has to pay compensation. That is contract. Contract is a legally binding agreement between two or more parties. Then tort. What is tort? Tort is a civil wrong. Tort is a civil wrong which results in a legal liability to the wrongdoer. Tort is a foreign word to us, so you have to just remember tort as tort. There is no particular meaning. Tort means civil wrong. Next, liability. Liability means it is your responsibility to make good to the other person. That is your liability. If you do a particular act, or if you do not do a particular act that you are supposed to do, both the things, action as well as omission. You do a particular act which you should not have done, or you do not do a particular act which you should have done. In those two cases, liability arises, a legal responsibility arises, and you have to pay compensation as a legal consequence. And judgment. Judgment is the final ruling given by the judge. In that, he will list out all the issues, he will list out all the evidences, he will list out all the reasons why he thinks a particular party is right or the other party is wrong, and then he will arrive at a judgment and say which party is wrong, which party is right, and also award damages or punishment to the wrongdoer. That is judgment. Then you have a precedent. Precedent is if an old judgment is quoted in a new judgment, in a new case, then the earlier one is called a precedent. Mostly the Supreme Court judgments are taken as precedents, authoritative precedent by all the courts in India, whereas High Court judgments are only guidance factors for one High Court to another High Court. But if you are a court within the same High Court, then that is also a authoritative precedent, you have to follow it. The precedent has the force of a law, you have to follow it. Next is statute. Statute is a law enacted by a legislative body. It can be parliament, it can be the state legislature. Then constitutional law, we have constitution. Constitution is the basic grand norm for a country. So all the laws in country are based on the constitution, and no law that is against the constitution can survive. Next, appellate court. You have two types of courts. One is the trial court, where you first give your application, you get your first judgment. If you are not happy with the judgment, you go in appeal. You can have appeal. That appeal wherever you go is called an appellate court. In India, we have first normal small causes courts and small courts and magistrate courts, and you will get a judgment on that. If you are not happy with the judgment, you can go in appeal. The first appeal goes to district court, second appeal goes to the high court. Now if the punishment is given by the district court or the sessions court, then the appeal will go to high court and second appeal will go to the Supreme Court. Now what is a trial? Trial is a formal legal proceeding which starts with your plaint, then you have your presentations, then you have your arguments, then you have your evidences, then based on that the judge will decide. This entire process is called a trial. Now habeas corpus, next word. Habeas corpus means bring the body. Habeas corpus means the body. Habeas means let me see the body. It is a legal action that prevents police from taking any person and keeping them at a different place without telling the family where he is. So you can go through the court. If supposing somebody is taken by the police and you don't know where he is, you can go to a court, file a habeas corpus petition and get the person produced before the court. Next, injunction. Injunction is a court order that requires a party to do certain thing or refrain from doing certain thing. It can be a temporary injunction, it can be a permanent injunction. Next is due process. Due process means fair treatment, protection of rights and a fair trial. That means I should be heard, my rights should be protected, and then the trial should be fair. Both sides should be given equal importance. No bias should be there. That is due process. Next, these are the few examples of the jargon in a court. Now let us see some concepts in criminal law. The concepts in criminal law are crime, mens rea, actus reus, strict liability. What is a crime? Crime is violation of IPC provision. Simple. In India, crime is violation of IPC provision or any other law that is in place of IPC, a criminal law. Right? Now, if you violate it, what happens? You will be subject to either imprisonment or a fine or a probation or things like that. Next, mens rea. There is a saying that without a guilty mind, any action taken by a person is no crime. So, action taken by a person is called actus reus or a guilty act, and then the mind that attaches to that particular act, the guilty mind, is called mens rea. These two words are Latin words, you have to remember them as they are. There is no equivalent in English. So, mens rea is a guilty mind, actus reus is a guilty act. Only when these two things happen together, you have a criminal liability, and this liability is imposed by the state and punishment is given by the state, and prosecution is also made by the state. Next is strict liability. Strict liability is where the guilty mind is not insisted upon. You just do an act and you will be punished. That is called strict liability, where guilty mind is not always necessary. Next, criminal defenses. Now, if you are an accused in a criminal case, you have been accused in a criminal case of a particular criminal action. Now, what are the defenses available to you? How can you protect yourself? The defenses available to you are, number one, self-defense. If somebody comes onto your house, into your property, into your home, or within your private space of your body, and he is trying to attack you, and you have the right to protect yourself as a self-defense. And in this process of self-defense, even if you have to kill the other person, then you are exempted from any charges. Next is under duress. If there is a situation where you are forced to do a particular thing under duress, either by a person in authority or a person of whom you respect much more, or by a group of people who force you to do a particular thing, and you have no option but to do a particular thing, that is called duress. Under duress, your punishment will go down, will be reduced. And if you are under intoxication, you are unable to make out good from bad, right from wrong. You will not even know what you are doing and why you are doing, kind of thing. If you are under effect of drugs or intoxication or alcohol, and that is also one defense where you will reduce, the punishment will be reduced. Next, insanity. You are mad. A mad person's actions are no actions because he doesn't know what he is doing. He is only, his body is acting, his mind has no control over his body. So in such a situation of insanity, no criminal liability attaches to a person. Then mistake of fact. You wanted to do A, you did B, and which resulted in a crime. Actually, your intention was not to do B, which results in a crime. You wanted to do A, but by a mistake of fact, you did B, and which became a crime. If you can prove it that way, then your punishment will be reduced. Then entrapment. If you are trapped into do a particular thing, somebody else has trapped you into doing particular thing, and you had no option but to do it, then your punishment will be reduced. Then necessity. Necessity is the last one. Supposing somebody steals a bread for a family member who is hungry, he is about to die, then that is necessity. That is the level of necessity that should be proved. If that kind of a necessity is proved, then that is no crime. Next, elements of crime. Now, what are the elements of crime? Is that you should have a mental state. There should be first an act, prohibited act. Second, you should have the attached mental state, mens rea. Then you should be causation, cause-effect relationship. And then you have attendant circumstances. These are the four things that are elements of a crime. So whenever you are trying to prove a crime or to disprove a crime, you have to either prove or disprove all these things. One, that act has occurred or not occurred. There is a mental state attached to it. Then there is a cause-effect relationship. Whatever has happened is caused by your action. There should be without any break in chain, there should be a causation should be there. Then attendant circumstances. What are the circumstances in which the particular thing has happened? These are the elements of a crime. Now criminal procedure. What is the criminal procedure? Is the procedure given under CRPC, which is followed by a criminal court, and it consists of, let us say, a complaint. It starts with a complaint or an FIR. Then it proceeds on to investigation. Then it leads to arrest of the accused. Then this arrest, after investigation, police submit a report to the court, and the court, the criminal court, holds a trial, calls for all the evidence and the reports and exhibits or witnesses and expert witnesses, hears all of them and notes down all the points for and against the person, and finally gives a judgment and sentences the individual for the crime he is accused of, or lets him off if he is not found guilty. Now it includes concepts such as search and seizure. During the course of investigation, police have the power of searching and seizing. You can seize the evidentiary material, you can search house, inside a vehicle, in the house, outside, and sometimes you need the permission of the court, sometimes you don't need permission of the court. Criminal acts are mostly called cognizable offences. In a cognizable offence, the power automatically comes to the police. You don't need a special power from the magistrate. If it is a non-cognizable offence, then they need a prior permission of the magistrate. Next are Miranda rights. Miranda rights is that if you make a statement, your statement will be used against you. This is in short Miranda rights. Somebody has to tell the accused while he is making a commitment, while he is making a statement, while he is accepting a liability, while he is making a confession, okay, that whatever statement he is making, whatever confession he is making, whatever acceptance he is doing on behalf of whatever the action and that has happened, the crime that is committed, then it will be used against him. This particular thing has to be notified to the person. That is called notification. Is called Miranda rights. Then right to a counsel. Every person has a right to an advocate. Suppose you don't have money, then what? Counsels don't come cheap, they come very costly. Nowadays the running rate is 1 lakh rupees. So if you don't have that kind of a money, you can always plead to the court. And then Legal Aid Act is there. Under Legal Aid Act, the Legal Aid Society is there. Under Legal Aid Society, a pro bono counsel is attached to you, free of cost. The state will provide the counsel to you, and he will take up your case and fight. Then there is another concept called presumption of innocence. That is, you are presumed innocent till proven guilty. Because this entire process of criminal procedure takes years. Now, if you presume him to be guilty right in the beginning and put him behind bars for all these years, and finally you find him that he is not guilty, then you would have already put him through lack of or robbing him of his rights, robbing him of his freedom, robbing him of his life for the entire period of the trial. So, which is prima facie not correct. So, you presume a person accused to be not guilty till it is proved otherwise. Only after it is proved that he has been conclusively proved beyond reasonable doubt that he has done a crime, then he will be accused, will become guilty person, and he will be sentenced. Next comes the burden of proof. Burden of proof in case of a criminal procedure is on the state, on the government. In case of a civil case, the burden of proof is on the plaintiff, the person who accuses a particular wrong. Then rules of evidence. There are rules of evidence under CPC, there are rules of evidence under CRPC, and you have Indian Evidence Act, which talks about facts, relevant facts and issues like that. So these are the rules of evidence that are to be followed. Next you have a felony and misdemeanor. Crimes are categorized into less severe and more severe crimes. Felonies are more serious offences, that cognizable offences, punishable more than 3 years punishment, even life, 7 years, 10 years, right? And misdemeanors are less serious, less than 2 years. They carry only fine or only a few days simple imprisonment. Sentencing: after the defendant is found guilty, the court will determine the appropriate punishment or a sentence based on IPC provisions. This sentencing, it depends on, again there will be a hearing separately for sentencing. There will be one hearing for deciding whether a person is guilty or not, then another hearing for finding out what is the appropriate sentence. Are there any circumstances, attenuating circumstances, which reduce the sentence? So it will depend on the nature and severity of the offence, defendant's criminal history, whether he is a repeater or not, any mitigating circumstances or aggravating factors like he is a repeater, and principles of proportionality and rehabilitation. These are all the sentencing items that will be discussed and sentence will be given. Next is vicarious liability. In certain situations, the principal or the main person is responsible for the act done by his agent. This is called vicarious liability. Rehabilitation, deterrence and retribution. These are the three principles of criminal law. These are theories of punishment. In one theories of punishment, one is rehabilitation. Whenever somebody has done, supposing a tribal kills an endangered animal. A tribal kills an endangered animal. Tribal lives in the entire jungle. The animal lives in the jungle. Tribal has perforce to go and kill animals to feed his family. So he goes and normally kills the other small animals, and one particular day he kills an endangered animal and he is caught by the people and subjected to entire trial process under criminal law. So that will entitle him to rehabilitation so that he can become reformed. And they will tell him, this is not the case, these are the animals which you should not kill, so better avoid doing that. And they will give him a simple punishment and release him. That's rehabilitation. Next is deterrence. Supposing you are a cheater, you are a 420, you cheat people by way of habit. So in order to prevent you from cheating more number of people, as a matter of deterrence, you will be put behind bars for a longer period. That is deterrence. Then retribution. You kill a person, you kill another human being, then the society will, without any particular reason, for money or for some other reason, then the society will retribute, will pay you back in kind. Retribution is nothing but paying back in kind. So these are the concepts which will give you an understanding of the criminal law. Now, next is the criminal procedure code, because forensics is mostly dealing with criminal matters, so we will deal mostly with criminal items, criminal side. Criminal procedure code is the legal framework that gives the procedures. IPC is a substantive law. Criminal procedure code is a procedural law, and the procedural law will give you the procedure in which the IPC has to be implemented. Simple. So the procedural law starts with FIR, then investigation, then prosecution, then adjudication, then punishment. These are the 4 steps in Criminal Procedure Code. Now, investigation. Investigation is the duty of the law enforcement authority or the police. They are being given this particular responsibility. A person will go to a police station and file a first information that a cognizable offence has occurred. And once you receive this information, they file what is called as a FIR. And this FIR, based on that, they will start an investigation. They go to the scene of crime, they observe everything, they analyze everything, then they try to search and seize and arrest a person who is accused, who is suspected. Then you interrogate the suspect, take his evidence, and find out people who are there who could have been their evidence, eyewitnesses, take their evidence, then gather all this evidence, gather material evidence, gather documentary evidence, gather eyewitness evidence, and you conduct identification, test identification parade, like people identify the persons who are involved in the crime, then present all these people with the relevant evidence to the court so that the investigation, the trial happens. Next is charging and indictment. In charging means you are charged with, after the end of the investigation, you file what is called as a final report or a charge sheet. Charge sheet is a list of charges against the accused. That this rule has been broken under section so and so. This rule has been broken under section so and so IPC. This rule has been broken under section so and so IPC. Like that, you make a series of charges, and this is submitted as a charge sheet. Then you have a bail and detention. Bail is leaving you out into the society during the process of the trial. That is bail, simple. And detention means keeping you inside, in the police control, so that you are not circulating in the society. These are the 2 opposite terms of bail and detention. In bail, an accused is let out into the society, and in detention, a normal person is withdrawn from the society and kept under control. Next, court proceedings. The court proceedings in criminal cases, it covers right of accused, evidence, examination, cross-examination, role of the judge or a magistrate. Next comes the judgment and sentencing. The judgment will decide whether he is guilty or not. Then he will decide which are the charges that are sticking, which are the charges that are superfluous. Then decide what is the punishment to a convicted individual. An appeal is there. Once first judgment is given, a punishment is given, you are given 30 days to 60 days time to go and appeal to the next level of courts. If you are in a magistrate court, you can go for district court in appeal. If you are punished by the sessions court or a district court, you can go to high court for appeal. Normally you have one appeal is always allowed in all criminal cases, and many times when a point of law is there in dispute, you are allowed a second appeal. Second appeal normally lies with the high court and supreme court. Next, difference between civil and criminal justice. Civil and criminal justice are 2 parallel lines. Civil justice handles dispute between private parties. Criminal justice is between society and the criminal. Parties involved in civil is 2 individuals, and the person who is suing has the responsibility to prove the case. In criminal justice, it is the society against the accused, and the prosecution is done by the state. The burden of proof in civil is on the person, plaintiff, and in criminal justice it is on the state. Then legal consequences are, in civil case you are given a punishment by way of damages or returning the property or performing a specific action. Whereas in criminal justice, you are given a fine or a probation or imprisonment. It can be simple imprisonment, it can be, and you can even have a life imprisonment, even up to death. The process and procedures in civil, it is typically a negotiation, discovery, evidence, pre-trial conference and trial. Nowadays, before every case, you have to go to other alternate dispute resolution mechanisms and come back to court if that is not successful. In criminal cases, no ADRs are there, no alternative dispute resolution mechanism is there. You are charged, your trial is made, and then you are sentenced. You can have an appeal on that. While civil and criminal justice are operate separately, there can be where a single incident may have both civil and criminal proceedings. For example, maintenance in case of a wife. You have a civil case, civil remedy, and you have a criminal section 125 criminal remedy. In both cases, you can file the case. Then what is fit? Fit is fitness to stand trial. Fitness to stand trial is supposing you are a person who is mentally unstable, who is mad, okay, and or you are a small child, you don't know what you are doing, below 7 years of age, below 10 years of age, okay, or you are a very old senile person, you have already lost your mind. So if these kind of people are there and they commit any crime, either knowingly or unknowingly, the court will decide that they are not fit to stand trial. It will first ask them questions, find out whether they are able to understand the importance or implications of action they done, they are able to answer questions rationally or not, and then decide whether they are fit for standing trial or not. Now, fitness to stand trial is important. Why? Because one, it protects the right of the accused, it ensures a fair trial and preserves the integrity of the legal system. Supposing you conduct the entire trial and then punish a small child of 4 years to death imprisonment or life imprisonment, the entire society will accuse you of being unfair, a legal system which is not civilized. Similarly, if a mad person is sentenced to death, similarly the entire legal system will be blamed for not being humane enough. So in order to balance these things, you see fitness of the person. Next is FIR. The criminal procedure is started based on the first information report. The criminal law is set into motion. What is first information report? The information about a cognizable offence given to the police first in the time, in a point of time, first in the point of time. It can be oral, it can be written, it can be on telephone, okay, and then it need not contain all the details, it need not be an encyclopedia of the entire crime. If sufficient details are there and sufficient details indicate a criminal act has been committed, and that is written down and then produced as a FIR, first information report, by the police, and then it is termed as a cognizable offence, and they'll start the investigation, they'll go to the scene of crime. Now, FIR, the primary purpose is to give a prompt information to the police. It is the initiation of investigation and legal proceedings. Now, what are the contents of an FIR? Typically, they have time, date, location, names and address of the complainant, the person who is complaining, and name and address of the person accused or the person who has committed a crime, description of the offence and how it falls under IPC provisions, and a narrative of the events that finally culminated in the offence. Okay, then legal requirement is that FIR is a legal requirement, it is a must for all serious crimes. And if you go to a police station, try to lodge an FIR, if the police SHO refuses to take it into account and write down an FIR, you have the option of going to their superior, SP of the district, and later on to the commissioner of the city, and then even you can go to the court to enforce your right of having an FIR registered for a crime that has been committed. An FIR creates an official record of the incident. It becomes a basis of investigation. It serves for the purpose of identification of arrest, to identify, locate and arrest the accused persons. It is a supporting evidence. It is not a substantial evidence. It is not the only evidence, but it is a supporting evidence in the trial. And legal rights, it indicates the legal rights and protections for the complainant as well as legal rights for the accused, and a fair trial has to be ensured. And it serves for public safety and deterrence, a prompt FIR being registered and prompt police swinging into action for public safety. It will go a long way in deterring similar offences being committed by others. The process and requirements for filing FIR may vary, but at the moment you have FIR and a zero FIR. Main issue with FIR is the jurisdiction. Many times wherever the act happens, we go to the nearest police station, which may not be the police station with proper jurisdiction. The proper jurisdiction may be some 10-12 kilometers away, but you don't have time. A murder has happened or a major crime has happened, and you go to the nearby police station and tell them. Earlier, they used to refuse to file an FIR, but now a process of zero FIR has come, where the police station without jurisdiction will note down your information, will call it a zero FIR. If it is required preliminary action, they will take and send it back after their action and their action taken report, send it to the police station which has the correct jurisdiction. Now, what is the object of punishment? What is the object of punishment? Object of punishment first and foremost is retribution. Society wants to pay back in kind. Retribution is, it is a paying back in kind by society to a person who has caused harm to a member of society. Next, it is a deterrence. Deterrence means it will create fear among others who are thinking of doing similar things. Then it is a rehabilitation. Rehabilitation is to reintegrate the person he has done by mistake because of lack of understanding, lack of education, lack of counseling, lack of training. If such a person has done any mistake, has broken a law, then you rehabilitating by giving him education, by giving him counseling, by giving him vocational training and interventions. Next is incapacitation. If you lock him up in the jail, you will be taking away a particular cause of irritation or crime to happen in a particular society. So you will be incarcerating or putting in house arrest or putting in a jail a person who is likely to commit further crimes. So further crimes are not committed. Next is restitution and restoration. Punishment is one way of restitution. The victim, it is from the victim side. You give it back to him for the harm or loss suffered. Okay, you will compensate him. Then restoration. You will restore him to a active life, active, socially productive, useful life in society. Then denunciation. Punishment will serve to tell everybody that the society views it with disdain, disapproval. Then it is important that objectives of punishment are intertwined, and it depends on the cultural, social and philosophical perspective on a case-to-case basis. But mostly in India, we try to lean towards rehabilitation, restitution and things like that. Retribution is the least part of our punishments. Now, what are different kinds of punishment in criminal law? What are the criminal law? Supposing you are found guilty, then what happens? What is to be expected? First thing is imprisonment. Simple and straight. IPC will list out. These are the things that you have done. You have broken the IPC law. So you will go in for this much period of time. It can be simple imprisonment. It can be severe. Then it will be fine. Fine will be there. Fine is allowed in addition to the jail. Then after serving for some time, you can be let off on probation, or even before serving, before starting your jail conditions, based on your time you have spent during the trial in a jail, the court may decide that subject to some conditions, you can let him off on probation, or you can put him up for community service. Then from the victim angle, there can be restitution and alternative sentences, that either you spend 5 years in jail or work for 3 years for a NGO. So that kind of alternative sentences can also be given for drug rehabilitation cases. Now about capital punishment. Capital punishment means death penalty. In many civilized countries, the death penalty has been taken out of the books, but in India we still have, and we use it for rarest of rare cases, mostly for terrorism related cases, and then any anti-state activities. These are the things for which we use rarest of rare cases. Now, nowadays the issue is about death penalty. A lot of discussion happens as to whether there should be, India being a democratic country, India being a civilized country and a very old civilization, should it have death penalty? If the society cannot give life, what right has it got to take away life? That is the death penalty discussion. The arguments in defense are that death penalty should be there, that it acts as a deterrence, it is a retribution justice, and for public safety it is required, and it will closure for a victim's families, and the issue will be closed for victims' families. Now the arguments against the death penalty is, once you kill him, irreversible, it is fallible. The judge is also a person, the prosecutor is also a person, the evidence is given by a person. So all these persons are human beings and fallible. So if there are errors, if there are mistakes, it is wrongly identified and wrongly punished, then you will be taking away life of an innocent person without ever knowing that he was innocent. Next, it is a violation of human rights internationally. The international community is not in favor of death penalty. Then it is ineffective as a deterrent. Do you mean to say just because you hang one person, others will not do the same act? That kind of a thing is not there, because if you want a person, an accused person, a criminal to reform and become a useful member of society, the method is not killing him but educating him, giving him some social support, changing his socio-economic conditions, like that. Then arbitrariness and bias. There is a lot of arbitrariness and discriminatory application in case of death penalty, because you persons who are of an inferior race are more commonly given death penalty. Persons with lesser socio-economic status are easily awarded death penalty. Persons who don't have a good lawyer, who cannot afford a good advocate, they always receive a death penalty. So these are things that are beyond the capacity of a person and beyond the crime itself. So in these cases it is against death penalty and for death penalty. You are free to make up your own mind and come to a conclusion. Now, another part is there are two kinds of rights. What are the kinds of rights? Primary rights and sanctioning rights. In primary rights are our rights which are there as a fundamental rights in Constitution. These are the primary rights. Primary rights are basic fundamental rights. That is, they are protected and enforced by the legal system. Okay. Now, right to life, liberty and security, civil rights, property rights, right to equality and non-discrimination. These are all our primary rights. Then sanctioning rights. Sanctioning rights are secondary rights. They are rights of the legal system to enforce and impose sanctions or penalties if you violate the primary right. They grant the legal system the power to take action against individuals who have infringed upon the primary rights. You break my fundamental rights, then I get a right to punish you, to go to the court and through the court to punish you and put you behind bars. That right of putting you behind bars and prosecuting you and punishing you is a sanctioning right. This is the sanction. We will write now in law. Law is what? You make an action, you break a law, and sanction comes from the authority. This is the sanctioning right. Sanctioning right is the enforcement of civil remedies. Regulatory powers are there, administrative actions are there. There are different kinds of sanctioning rights. Next, if you want to study sanctioning rights in detail, you will have to go back to the Constitution, which is our grand norm. Fundamental rights are the primary rights. Right to equality, that is primary right. Right to freedom, Article 19 to 22 is our primary right. Right against exploitation, Article 23-24, they prohibit trafficking, forced labour and child labour. Right to freedom of religion, Article 25 to 28, they ensure freedom of religion, freedom to profess, practice and propagate religion. Cultural education rights 29 to 30, right of minorities. Right to constitutional remedies, Article 32, sanctioning rights in Constitution of India. Now, sanctioning rights, what do you have? We have the power of judiciary, of judicial review, striking down laws, executive actions, power of the legislature to enact laws and enforce fundamental rights, power of the executive to enforce the fundamental rights and then punish or catch and arrest the people who violate laws. These are the sanctioning rights. This is how you differentiate between primary rights and sanctioning rights. Primary and secondary functions of the courts of law in India. What are the functions of courts of law in India? Primary functions are adjudication of dispute, we have already seen. Interpretation of law, we have seen. Protection of fundamental rights, we have seen. Judicial review. Judicial review is if a particular action is taken by the executive, it is felt that it is against the Constitution, you can go to Supreme Court or High Court and ask for a judicial review of that particular action. If a law is passed by the legislature, which you feel is against the constitution, you can go to the Supreme Court and ask it to be struck down. That's called judicial review. Now, secondary functions of the courts are precedent setting. Supreme Court has the precedent setting judgment power in the entire country. High Court has a precedent setting power in the entire state. District courts do not have that kind of a thing. Then dispute resolution. There are forums for alternative methods of dispute resolution. What are the alternative methods other than the court method? Are mediation, arbitration, negotiation, and settlement discussions. Then you have case management. Other duty of the court is to manage the cases, proceeding of the case, scheduling of the case, maintaining records, ensuring smooth functioning of the judicial process. For this purpose, you have office is there adjacent to the judge chambers. They run this. Contempt of court authority is there. The courts will not be able to function fearlessly unless they have the power to punish somebody who refuses to acknowledge their authority. That's called contempt of court. Then judiciary officers, say High Court, they have got administrative powers also. They are the administrative head of all the courts within the state. So they decide on leave matters, they decide on transfer matters, they decide on joining, they decide on retirement, they decide on various other facilities that are to be given to other judges. So this is called judicial administration, appointing rules, regulations, etc. Now high courts and district courts, what are the other? High courts are the appellate jurisdiction. They have appellate jurisdiction. That means any decision taken by the district court or below that, appeals can come to high court. They will decide on that. Original jurisdiction, some cases have started, they are first mooted in high court, like writ jurisdiction. Writ cases are, they come to the original jurisdiction. Supervisory role, high court supervise the working of all the judicial officers within a state. And then judicial review, high courts and Supreme Court has the power of judicial review. High court reviews those laws and actions of executive within the state. Supreme Court reviews throughout the country. Then control over subordinate judiciary they have. Now in the case of district courts, what is the activity? They have original jurisdiction. They hear and decide civil cases, including property, contract, family matters. In criminal cases, district courts conduct trials, session trial. In appellate jurisdiction, if a case is decided by a lower judiciary or the magisterial courts, then the appellate jurisdiction comes to the district court. They execute the judgments given by other courts or other higher courts in their jurisdiction. The judicial magistrate functions, district courts will handle criminal cases at a lower level. Then it is important to note that the functions and jurisdiction of high court and district courts can vary. Then differentiate the powers of executive magistrate and judicial magistrate. Who is executive magistrate? Executive magistrate is the collector. Judicial magistrate is the judge. There used to be earlier some judicial functions bestowed on the executive magistrate, but nowadays both of them completely separated. Executive magistrates do not have any more judicial adjudicatory powers. They have only preventive powers. Before a crime occurs, and judicial magistrates take over the moment the crime occurs and the consequences after that. If you understand this much, it is enough. Executive magistrate have more of administrative functions. They are responsible for maintenance of law and order, public peace and tranquility. They supervise the police and they maintain public order. They issue section 144 orders, more than 5 persons not to come together or carry weapons. They order arrest and detention. There can be even preventive detention also. There are administrative magistratal inquiries. They have administrative inquiries in clashes, custodial deaths, etc. In the case of judicial magistrate, they have mainly judicial functions. That is, after a crime has been committed, they preside over criminal trials. They decide on the bail and remand, and they have cognizance and inquiry. They take cognizance of a crime and order inquiry. Magisterial inquiries are also inquired into by the judicial magistrate. Now, what are the different kinds of laws that combat a crime? Criminal codes are there. There are wide range of crimes are there. Crimes against persons like murder, assault and rape, for which you have IPC. Offence against property like theft, burglary and fraud, for which again you have IPC. Offence against public order, rioting, public disturbance, you have many other laws in addition to IPC. Anti-money laundering, PML laws, AML laws are there, Prevention of Money Laundering Acts. Then you have cyber crime, and Information Technology Act is there. We have already studied that. That is hacking, identity theft, phishing, cyber fraud, unauthorized access. Then you have drug control laws, laws related to NDPS Act, that is production, trafficking and abuse of illicit drugs. And firearm laws are there, Regulation of Arms Act, firearm laws are there. Then you have anti-corruption laws, criminalized bribery, embezzlement, abuse of power. These are all CBI cases. Then human trafficking laws, we have anti-human trafficking. International conventions are there, as well as our own laws are there for forced labor, sexual exploitation and organ trafficking. Domestic violence laws are there, Protection and Domestic Violence Act, that act we have. Then you have IPC versus CRPC. IPC is a substantive criminal law which defines the rights and liabilities and gives what are the crimes and what is the punishment for each crime. Offense definitions are given under IPC. Punishments are also listed out under IPC. It has general provisions that apply to multiple offences. There are exceptions and defences. IPC provides for general exceptions. When an act, even though which looks on the face of it as a crime, is not a crime because of the general exception. One of the major general exception is the self-defense and insanity. CRPC decides with the procedural law. It deals with FIR, investigation, trial, procedure. And CRPC defines the jurisdiction of different courts. It defines who will go in appeal where and what are revisionary powers of the High Court. Then general exceptions under IPC. General exception under IPC is first consent. A person who consents to a particular situation. Suppose you go for bungee jumping. You sign a consent form and you jump and the thread breaks and you fall to your death. That is by consent. There is no criminal liability to the person who allows you to do that bungee jumping. Then private defense under 96 to 106 sections. If somebody attacks you or your property or people in whom you are interested, your family members, there is an imminent threat to life or to property or to the body of the person, you have the right to stop such unlawful aggression by even killing the other person. Then next is necessity, 81 to 85. Like a person who steals a bread because he is hungry, that is, and who kills an animal even though it is an endangered animal, if that animal is attacking you, these are necessity. Then by mistake, who commits an offence under a genuine and reasonable mistake of belief. He thought it is not a crime, but it finally turned out to be a crime, that is mistake. And judicial acts, the act of judges, public servants who act under good faith or under rule of law, they are not doing any crime even though the action they take is either taking away your life or liberty or even taking away your property. Accident we have different laws where the intention or knowledge is required, that has to be established. If there is no intention but it is accidental, then it is by mistake, it will not have any criminal liability. Now civil and criminal cases. Nature in civil case arises because of dispute between two individuals, organizations or entity with reference to their right, liability or interest. In a criminal case, it is against the society. Parties in the civil case, there are two individuals. In criminal case, it is government versus the accused. Burden of proof in civil case is with reference to one person. In a criminal case, the burden of proof is with the prosecution or the government. And in civil case, it results in damages, injunction or a specific performance. In a criminal case, if he is found guilty, he is put behind bars and fine and probation. Now, essential elements of criminal law are actus reus, we have discussed, mens rea, we have discussed, concurrence of act and intent. Actus reus should accompany the mens rea and causation should be there. There should not be any break in the cause. That means your act should finally result in a particular crime and it should be within the four bounds of the law. Then criminal courts are there. Structure of judiciary, highest is the Supreme Court. Below that you have high courts. Below that you have district courts. Below that you have judicial magistrate courts. And sessions court is at the district level, which tries all major crimes. In a criminal trial, the process is FIR, then arrest and investigation, then filing of charges, then initiation, and then bail provisions, then plea provisions, then pre-trial proceedings, then trial, that goes on, and finally verdict and sentencing. Now there are two words that you should understand: cognizable and non-cognizable. Cognizable are the cases where a crime is committed, it is punishable beyond 3 years, and once it is a cognizable offence, the police get automatic right to take you into custody, to search and seize, and to go to the scene of crime and start investigation. In case of a non-cognizable cases, it is less than 2 years. Then in that case, you have to take the court's permission. The police cannot get a right to start investigation straight away or to file a case. They can only take a complaint and then go to the court and get their power to either to search, seize or arrest or take action or investigate. Then you have bailable and non-bailable cases. In case of a bailable case, which is given in a list in a schedule to the CRPC, so bailable cases, the police itself can grant bail at the police station level. In non-bailable cases, the bail is granted in non-bailable cases also, but it is granted by the judge or judiciary, not by the police. And non-bailable cases, the bail is granted based on certain conditions and some amount being deposited or some sureties being given. Okay, the rule by Supreme Court is that bail is a matter of right and jail is an exception. Bail is a right, is the correct and the first choice, and jail is an exception. And discretionary bail is there in non-bailable cases for the court. Anticipatory bail provisions are also there. If you are really anticipating an arrest, you can go for anticipatory bail. In anticipatory bail, you will be arrested, but the moment you are arrested, if you show the anticipatory bail, you will immediately be granted bail. Bail denial, bail rejection and appeals are there. Up to Supreme Court you can go. And presumption of innocence is there. Supreme Court always emphasize the accused is also a person and he has the right of being presumed innocent until proven guilty. And this in his individualized approach, each case is taken separately. Personal liberty has to be guaranteed by Constitution, has to be respected in all cases. And non-denial based on the gravity of offence. Only if it is very gravity of offence is there, you can refuse bail, and that too for a particular period of time. And the trial has to be very speedy. Now, bail is the rule and jail is an exception statement. There are many. Bail is the rule, jail is exception. It depends on the underlying idea. Individuals should not be subjected to pre-trial detention. Significance of this principle is in safeguarding the personal liberty of the individual. Important to note that the grant of bail in determination of exceptional circumstances are based on what the court and the law on the date it happens. And powers of Chief Judicial Magistrate. His jurisdiction has original and appellate cases in their territorial jurisdiction. They can hear and decide cases involving offences where they have granted the authority. Sentencing powers of CJM impose sentences within 7 years. Then imprisonment for a specific term, fine for an unlimited amount, compensation depending on the damages, discretion in sentencing lies with the CJM, appellate jurisdiction or the JMs, then it is lies with the Sessions Court and Higher Court. 7-year sentence, 10-year sentence, 2-year sentence, life sentence, death sentence. These are the different sentences we see in India. Death sentence is rarest of rare cases. Death sentence is only for rarest of rare cases. Life sentence is all for murder and things like that, very serious and grave offences. 10-year sentence is also for grave offences, but with some factors that are mitigating factors are there. 7 years with more mitigating factors. 2 years is for all small and non-serious cases. Okay, so this is the introductory part of the law we have discussed, and from now onwards we will see IPC, Indian Evidence Act, and CRPC, different provisions on them, and we will discuss them in detail. Okay, so we will close the class today unless you have any questions to ask. Any questions, please?
No, sir, not now.
Okay, thank you. You can leave the.
Okay, thank you, sir.